we are going to be presenting end of chapter for business law. This is our group members. My name is LAILA QAMARINA, binti Ismi Haidar. My matrix number is 10 DPM 22F1054.
My name is DINI Erdina binti Muhammad Nazri. My matrix number is 10 DPM 22F1052.
Hi, Assalamualaikum. My name is ALIAH Inani binti Muzammel. My matric number 10 DPM 22F1073.
My name is Muhammad Denail Muhammad Nayan. My matrix number is 10 DPM 22F1091.
My name is NURUL binti Nur Azman and my matric card number is 10 DPM 22F1081.
There are two situations and questions that we are going to be answering in this video. The first question is, Azri and Awa has been married for 15 years. One day, Azri went on station for 3 days and left his credit card for Awa to use in emergency situations. Before he left, Azri also provided Awa RM300 as an allowance. After Azri left their house, Awa used Azri's credit card to buy 4 pieces of clothing from a famous brand named Swan. After a month, Azri received a credit card bill. Although the bill was in his name, he refused to pay as the debt was not his but his wife. We are required to describe an issue that arises from this scenario, explain the relevant provision under the Contract Act 1950, propose a relevant case to support your answer, and justify a good conclusion for the above issue. Question 2. Jamal bought a car, Honda City, from Zainal and has been using it for several months. Jamal was later discovered that Zainal did not have the legal rights to the car. The car is still property of Shahrul. Jamal had to give the car to Shahrul and claim the money that has been paid. Zainal refused to hand the money to Jamal. We are required to describe an issue that arises from this scenario, explain the relevant provision under the Sales of Goods Act 1957, propose a relevant case to support our answer, and lastly, complete a good conclusion for the above issue.
For question 1A, the answer is Mr. Azri obligated to pay the debt that was owed by his wife?
B. Explain the relevant provision under the Contract Act 1950.
Section 140. Definition of express and implied authority. An authority is said to be expressed when easily given by words spoken of written. An authority is said to be implied when easy to be inferred from the circumstances of the case.
I will explain about the question number 1 for the answer number C. C. Propose a relevant case to support your answer. Case Miss Gray vs. Cathcart, 1992. Explanation: a wine was supplied with clothes of the value of £250 by a shopkeeper. The shopkeeper sued the husband. It was found that the husband was giving the wife an allowance of £960 per year. It was held that the husband was not liable to pay the dues of the shopkeeper.
For the question D, justify a good conclusion to the above issue. Mr. Azri is not obligated to pay the debt that was owned by his wife. In accordance to Section 140 and the case Miss Gray vs. Cathcart, because of Azri has given a spending allowance to his wife so that she can buy necessities in cash. Furthermore, Azri's credit is given to Awa to use in emergency situations only, not for buying necessities.
Here are the answers for question 2. A. Describe an issue that arises from the scenario. Can Jamal legally claim the money that he has paid to Zainal?
B. Explain the relevant provision under the Contract Act 1950.
Section 14A. Implied undertaking is title. In a contract of sale, unless the circumstances of the contract are such as to show a different intention, there is an implied condition on the part of the seller that in the case of a sale, he has a right to sell the goods, and that, in the case of an agreement to sell, he will have a right to sell the goods at that time when the property is to pass.
For question 2C, the answer is Roland versus Diwali. The plaintiff bought a motor car from the defendant and used it for several months. It then appeared that the defendant had no title to it and the plaintiff was compelled to surrender it to the true owner. The plaintiff sued the defendant to recover back the purchase money that he had paid as on a total failure of consideration, held that notwithstanding that he had the use of the car, the consideration had totally failed and he was entitled to get the purchase money back. The use of the car that he had was no part of this consideration that he had contracted for, which was the property in and lawful possession of the car, whereas what he got was an unlawful, which exposed him to the risk of an action at the suit of the true owner.
D. Complete a good conclusion to the above issue. Jamal is entitled to reclaim the money that he has paid to Zainal in accordance to the case Roland versus Diwal and Section 14A. This is because Zainal did not have the right or the title to the car when he sold it to Jamal.